is Mike Arnold. People in Nigeria, some of them call me Earthshaker.
In October 2025, Nigeria's National Security Advisor, Nuhu Ribadu, personally invited a small city mayor from Blanco, Texas, a town of approximately 1,700 people, to Abuja. The stated purpose: for this American to meet certain key people and then declare the truth. 6 months later, that same American was sitting before the United States Congress, calling for the arrest and indictment of President Bola Tinubu and top Nigerian officials for genocide. While everyone is talking about what Mike Arnold said about Nnamdi Kanu at Congress, nobody is asking the question that should be asked first. What did the Nigerian government think it was getting when it invited this man to Abuja? And how did it end up giving him the platform that he eventually used against it? Because the answer to that question tells you something important about how political miscalculation works at the highest levels, and it opens a dimension of the Kanu case that the Tinubu government has never publicly addressed. Stay with me. This is more layered than it looks. Before we go further, if you're new here, this channel exists for one reason: to give Southwest Nigeria the political analysis mainstream media won't. Hit subscribe and stay with me. This gets deeper. Mike Arnold is the former elected mayor of Blanco City, Texas, a small hill country town with a population of roughly 1,700. He holds an executive MBA from the University of Texas. He first visited Nigeria in 2010 as a board member of Unity for Africa. He has since made 16 documented trips. In 2019, he co-founded Africa Arise International, a Nigerian-led nonprofit that runs schools for internally displaced children in the Federal Capital Territory. He has also served on boards, including one alongside former President Yakubu Gowon. Arnold is a committed Christian missionary with a documented pattern of framing Nigerian security and governance through a Christian-Muslim conflict lens. His website describes him as the most famous American in Nigeria. He has been quoted in major Nigerian newspapers and appeared in viral video interviews. He is known to be sympathetic to the Biafra movement and is an explicit supporter of Nnamdi Kanu's release. He is not a U.S. government official. He has no diplomatic standing. His congressional appearance was a private citizen briefing, the kind that advocacy organizations and individuals regularly deliver to congressional committees on foreign policy matters. It carries significant political weight as public testimony on the record, but it does not represent the position of the U.S. government.
In April 2026, Arnold delivered a formal statement to a U.S. Congressional Committee on Nigerian Security, Governance, and Human Rights. The full title of his statement was Formal Statement on Widespread Violence and Displacement in Nigeria. He presented himself as a private citizen with direct Nigeria experience, 16 visits, including 6 extended investigative missions since 2019. His key claims included: the Tinubu government is guilty of genocide against Christians in Nigeria. Between 10 and 12 million people, mostly young, have been displaced by violence. The government denies the existence of certain displacement camps even in the federal capital. The case of Nnamdi Kanu represents selective justice, specifically that a northern Nigerian Islamic cleric who publicly placed a 1 million naira bounty on a Christian pastor's head faced no charges, no arrest, and no government condemnation, while Kanu serves life imprisonment. On Kanu specifically, Arnold stated, Nnamdi Kanu, leader of IPOB and founder of Radio Biafra, British-Nigerian dual national, abducted from Kenya in June 2021 in what international human rights organizations have characterized as an extraordinary rendition. In November 2025, convicted on terrorism-related charges and sentenced to life imprisonment. The law under which portions of his conviction rests was not in existence at the time of the alleged conduct. The critical context that most reporting has missed is how Arnold came to have this platform in the first place. Arnold has publicly stated that he was personally invited to Abuja in October 2025 by National Security Advisor Nuhu Ribadu and by Reno Omokri, described as the president's international PR advisor, to meet certain key people and then declare the truth. He delivered a press conference at the Abuja Hilton on October 14, 2025, which he described as a government-sponsored event at which he blew the whistle on the Nigerian genocide. The Tinubu government has not publicly confirmed or denied that it facilitated Arnold's October 2025 Abuja visit. It has not issued a formal response to his congressional testimony. That silence is itself a political posture, and it is not the posture of a government that is confident the allegations are false. Arnold's congressional testimony in April 2026 comes at a specific moment in the Kanu case, 6 months after Kanu's November 2025 life sentence, while his appeal is presumably being prepared, while Southeast governance and traditional rulers are publicly calling for a political resolution, and while the Tinubu government is managing a 2027 re-election calculation that includes the Southeast's political alignment. Arnold's testimony internationalizes the Kanu question at the precise moment when the domestic political pressure for resolution is also at its peak.
Nnamdi Kanu was convicted on November 2025 on 7 counts under the Terrorism Prevention Act 2011 and related legislation. He was sentenced to life imprisonment. Judge James Omotoshu ordered that he be prevented from access to mobile devices and broadcast equipment except under security supervision. He is currently held at a correctional facility in Sokoto State. The factual background: Kanu was first arrested in Nigeria in 2015. He was granted bail and jumped bail in 2017. In June 2021, he was detained in Kenya and rendered to Nigeria, a process his lawyers and international human rights organizations, including Amnesty International, have characterized as an extraordinary rendition. His terrorism trial ran from 2015 to November 2025, a period of 10 years. The most legally substantive claim in Arnold's testimony, and one that predates Arnold and has been made by Nigerian constitutional lawyers, is the retroactivity argument. The Terrorism Prevention Act was passed in 2011. The conduct for which Kanu was convicted, including Radio Biafra broadcasts advocating Biafran independence, occurred between approximately 2009 and 2015. The legal principle is known as nullum crimen sine lege, no crime without a law. Applying a 2011 law to conduct that occurred in 2009 or 2010 raises a fundamental constitutional question that should have been addressed by the appellate courts. Whether this argument succeeds on appeal depends on how the courts read the specific charges, the dates of the alleged conduct, and which provisions of the Terrorism Prevention Act were applied. The Nigerian government has not issued a public legal response to this argument. It is one of the grounds that Kanu's legal team is expected to pursue on appeal. The retroactivity argument is a legitimate legal argument raised by Nigerian lawyers, not invented by Arnold. Arnold's characterization of it before Congress is accurate in substance. However, whether it will succeed on appeal is a separate judicial question that remains open. The manner of Kanu's return to Nigeria from Kenya in June 2021 has been described by multiple international human rights organizations as an extraordinary rendition, meaning his transfer was carried out without extradition proceedings, in potential violation of Kenya's sovereignty and international legal norms. Kenya's government raised concerns about this at the time. The UN Working Group on Arbitrary Detention issued opinions on Kanu's detention. The ECOWAS Court of Justice has also considered aspects of his case. These are not allegations, they are documented international legal proceedings and opinions. Whether they are sufficient to overturn his conviction in a Nigerian court is the question his appeal will need to answer. Nnamdi Kanu was convicted on November 2025 on 7 counts under the Terrorism Prevention Act 2011 and related legislation. He was sentenced to life imprisonment. Judge James Omotoshu ordered that he be prevented from access to mobile devices and broadcast equipment except under security supervision. He is currently held at a correctional facility in Sokoto State. The factual background: Kanu was first arrested in Nigeria in 2015. He was granted bail and jumped bail in 2017. In June 2021, he was detained in Kenya and rendered to Nigeria, a process his lawyers and international human rights organizations, including Amnesty International, have characterized as an extraordinary rendition. His terrorism trial ran from 2015 to November 2025, a period of 10 years. The most legally substantive claim in Arnold's testimony, and one that predates Arnold and has been made by Nigerian constitutional lawyers, is the retroactivity argument. The Terrorism Prevention Act was passed in 2011. The conduct for which Kanu was convicted, including Radio Biafra broadcasts advocating Biafran independence, occurred between approximately 2009 and 2015. The legal principle is known as nullum crimen sine lege, no crime without a law. Applying a 2011 law to conduct that occurred in 2009 or 2010 raises a fundamental constitutional question that should have been addressed by the appellate courts. Whether this argument succeeds on appeal depends on how the courts read the specific charges, the dates of the alleged conduct, and which provisions of the Terrorism Prevention Act were applied. The Nigerian government has not issued a public legal response to this argument. It is one of the grounds that Kanu's legal team is expected to pursue on appeal. The retroactivity argument is a legitimate legal argument raised by Nigerian lawyers, not invented by Arnold. Arnold's characterization of it before Congress is accurate in substance. However, whether it will succeed on appeal is a separate judicial question that remains open.
The manner of Kanu's return to Nigeria from Kenya in June 2021 has been described by multiple international human rights organizations as an extraordinary rendition, meaning his transfer was carried out without extradition proceedings, in potential violation of Kenya's sovereignty and international legal norms. Kenya's government raised concerns about this at the time. The UN Working Group on Arbitrary Detention issued opinions on Kanu's detention. The ECOWAS Court of Justice has also considered aspects of his case. These are not allegations, they are documented international legal proceedings and opinions. Whether they are sufficient to overturn his conviction in a Nigerian court is the question his appeal will need to answer.
Arnold's most politically potent claim before Congress was the contrast between Kanu's prosecution and the case of a northern Nigerian Islamic cleric who publicly offered a 1 million naira bounty for the head of an unnamed Christian pastor accused of insulting the Prophet Muhammad. According to Arnold's testimony, when public calls for arrest followed, the cleric doubled the bounty to 2 million naira on video, explicitly daring the DSS to arrest him. Arnold stated, no charges filed, no arrest executed, no formal government condemnation issued. The cleric's identity and the exact facts of this case have not been independently verified by this production and must be verified before you script this section. The broader argument that Nigeria applies terrorism law selectively based on the identity of the accused is a documented claim that has been made by Nigerian civil society, Southeast politicians, and constitutional lawyers, independent of Arnold. Verify the specific cleric's name and the police or DSS response before including this in your delivery. Present it as Arnold's testimony, not as independently confirmed fact, unless you have verified it from a separate Nigerian news source. The most direct, immediate beneficiaries of Arnold's congressional testimony are the IPOB diaspora community and Kanu's legal team. International attention on the case, particularly attention that raises verifiable legal questions about retroactivity and rendition, creates political cost for the Nigerian government in its international relationships. The more the Kanu case is seen as a selective justice issue rather than a genuine terrorism prosecution, the harder it becomes for Tinubu to maintain the narrative that Kanu is simply a convicted terrorist. The secondary beneficiary is the Southeast political class, governors, traditional rulers, and senators who want a political solution to the Kanu question but need international pressure to create the political cover for Tinubu to act. Southeast Governors Forum Chairman and Abian Governor Alex Otti has publicly said he is happy to work with other well-meaning Nigerians who genuinely want this problem resolved. Former Abia Governor Nnamdi Kanu has said the problem needs a political process. These are invitations for exactly the kind of international pressure Arnold is generating. The Tinubu government carries the primary political risk from Arnold's testimony. The specific damage is not Arnold's claims about genocide. Those are contested and the government can dismiss them as advocacy. The specific damage is the retroactivity argument. If an American activist can credibly tell the US Congress that Nigeria convicted a man under a law that didn't exist when his alleged crimes occurred, and the Nigerian government cannot publicly rebut that claim, it suggests the government knows the appellate case is legally vulnerable. NSA Nuhu Ribadu is in a particularly exposed position. If Arnold's account of the October 2025 invitation is accurate, that Ribadu personally invited him to Abuja, then a senior Nigerian national security official either failed to anticipate how Arnold would subsequently use his Nigeria platform or miscalculated the degree to which Arnold would turn against the administration after his visit. Either reading is damaging to Ribadu's credibility.
The Kanu case is directly tied to the Southeast 2027 political alignment. The Southeast withheld significant support from the APC in 2023, voting heavily for Labour Party's Peter Obi. Tinubu needs to improve APC's Southeast performance in 2027. The pathway that Southeast political actors have described, including Otti and Kalu, is a political resolution of the Kanu case as a goodwill gesture that creates space for APC Southeast reconciliation. Every month that Kanu remains in a Sokoto prison, and every month that international advocates like Arnold keep the selective justice narrative alive, makes that reconciliation harder to achieve. The 2027 electoral clock is the actual deadline driving the political urgency around this case, not the legal timeline. The Southwest's stake in this case is indirect but real. A Tinubu government that is seen internationally as conducting selective prosecutions for political purposes is a government that is diplomatically weakened, and a diplomatically weakened Nigerian president is a weaker bargaining partner for all of Nigeria's international interests, including those that directly affect the Southwest's economic trajectory, Eurobond access, IMF program management, diaspora investment confidence. Additionally, the precedent of life imprisonment for speech acts, even speech acts that many Yoruba political figures find deeply objectionable, creates a legal template that is available to be used against anyone. The principle of selective justice does not stay contained to its original target. That is the Southwest's direct constitutional interest in how the Kanu case resolves. Now,
If what I just told you surprises you, drop a comment below. I want to know what you think before we get to the part that changes everything.
Kanu's life sentence has not resolved the security situation in the southeast. It has, if anything, accelerated it. Sit-at-home compliance in the southeast remained high in the immediate aftermath of the conviction, though there are reports of partial normalization. The economic toll of years of Monday sit-at-homes, lost trading days, school disruptions, transport shutdowns has been documented by Enugu and Anambra state economic agencies in the billions of naira. The imprisonment of Kanu did not end that economic disruption. It has not produced the security improvement the government argued would follow. The Kanu case is inseparable from the question of what speech is permissible in a federal system that contains genuinely diverse political aspirations. Nigeria's constitution guarantees freedom of expression. It also prohibits secession. The tension between those two provisions has never been adjudicated cleanly by any Nigerian court. The Kanu case was an opportunity for that adjudication. Instead, the trial lasted 10 years, the conviction came on terrorism grounds rather than a clear free speech versus secession ruling, and the legal questions remain unresolved in the case law. Arnold's most nationally significant claim, regardless of its source, is the selective justice argument. If it is true that a northern Nigerian cleric who publicly placed a bounty on a pastor's head faced no prosecution, while Kanu serves life for speech acts, that disparity does not just affect the southeast. It signals to every Nigerian across every region that the application of terrorism law is negotiated rather than principled. That signal undermines every Nigerian institution simultaneously: the judiciary, the prosecution service, the executive, and ultimately the democratic legitimacy of the government.
Nnamdi Kanu holds British nationality. He was convicted for conduct that included Radio Biafra broadcasts made in London. The United Kingdom has a well-established foreign policy practice of making representations to foreign governments when UK nationals are convicted abroad, particularly where the conviction involves speech acts that would not be criminal in the UK. The UK government has made no public statement on Kanu's November 2025 life sentence. That silence is a political position. It reflects either a calculation that British-Nigerian diplomatic and economic interests outweigh the obligation to Kanu specifically, or a private assessment that Kanu's conduct went beyond protected speech in a way that reduces the UK's diplomatic obligation. Either reading deserves to be put to the UK Foreign Office. It has not been, publicly, by any major news organization. Arnold's congressional briefing is part of a broader pattern of US congressional attention to Nigerian security and governance that has intensified since 2023. Multiple congressional hearings have addressed the farmer-herder conflict, Christian persecution claims, and democratic governance in West Africa. These hearings do not automatically produce legislation or policy change, but they create a public record, and that public record is consulted when the State Department makes aid allocation decisions, when Treasury makes financial sanctions decisions, and when the IMF conducts Article 4 consultations with the Nigerian government. The Nigerian government has not formally responded to Arnold's testimony. It has not submitted a rebuttal to the Congressional Committee. That absence from the record is a strategic error, regardless of whether Arnold's claims are accurate. Unanswered testimony in a congressional record effectively stands unchallenged. Yoruba communities in the UK and US have a complicated relationship with the Kanu case. Many in the Southwest do not support Biafran separatism and do not regard Kanu as a political ally. But the selective justice argument, and specifically Arnold's contrast between Kanu's prosecution and the impunity of the cleric who offered a pastor's bounty, resonates in diaspora Yoruba communities that have their own documented concerns about security for Christians in Nigeria's north. For Igbo diaspora communities, particularly those in London, Houston, and Atlanta, Arnold's testimony is being received as international validation of what they have argued for years. The risk is that diaspora emotional investment in Arnold as an ally causes them to accept all of his claims, including those that are contested or unverified, as fact. The more measured diaspora response would be to amplify the specific, verifiable legal arguments while pressure testing the broader genocide framing.
Arnold's role in this story fits a documented global pattern. Private foreign citizens with genuine country relationships and advocacy platforms who internationalize domestic political cases, creating diplomatic costs for governments. The pattern has appeared in cases involving China and Uyghur advocates, Russia and opposition figure supporters, and now Nigeria. The strategic question for the Tinubu government is not how to discredit Arnold. That effort has largely failed. It is how to give the international community a credible counter-narrative. The absence of any public rebuttal to his congressional testimony suggests the government has not yet developed one. The Nigerian government's strongest honest argument on the Kanu case is this: Nnamdi Kanu did not merely advocate for Biafran independence. He ran an organization, IPOB, that has been listed as a terrorist group by the Nigerian government. During the period of his trial, IPOB-linked violence in the southeast killed police officers, destroyed property, and contributed to the sit-at-home compliance that has damaged the southeast economy for years. Whatever one thinks of the trial's procedural fairness, the claim that Kanu was convicted purely for words spoken in the UK is an oversimplification that ignores the documented activities of the organization he led. On the rendition question, Nigeria had a valid arrest warrant for Kanu when he was picked up in Kenya. The manner of his transfer may have been procedurally irregular under international law, but the underlying warrant was not invented. The Nigerian state had a legitimate interest in trying a person against whom serious charges had been laid and who had jumped bail. On Arnold specifically, he is a private American citizen with documented Christian missionary commitments and a known IPOB sympathetic viewpoint. His congressional testimony represents one perspective in a genuinely contested political and legal case. It should be weighed accordingly, as advocacy, not as intelligence or legal authority. Arnold exposed Tinubu's secret. Arnold did not reveal previously hidden information. The facts of the Kanu case, the rendition, the 10-year trial, the retroactivity legal argument are all on the public record and have been reported by Nigerian and international media. What Arnold did was bring these documented facts to a US congressional audience and frame them in terms of Christian persecution and selective justice. The secret framing is a YouTube title convention, not an accurate description of what the testimony contained.
The US government is moving against Tinubu. Arnold's congressional briefing does not represent a US government position. The State Department has not issued any sanction notice, travel ban, or formal diplomatic complaint arising from Arnold's testimony. Conflating a private citizen's congressional briefing with a US government policy action is a significant error that will damage your channel's credibility if you allow it. Kanu should be immediately released. The legal question and the political question are separate. Even those who believe the trial was procedurally flawed, and many serious lawyers do, are not arguing for immediate executive release outside the legal process. They are arguing for proper appellate review, and separately, a political resolution framework. Those are different demands with different institutional implications. The Southwest's strategic interest in the Kanu case is not about whether Kanu should or should not be released. The Southwest's strategic interest is in the principle being established. If the current approach, life imprisonment for speech acts under a terrorism law whose retroactive application is contested, following a rendition that bypassed extradition procedures with no appellate decision in sight, becomes the established template for how Nigeria handles political dissent, then that template is available to be used against Southwest political voices. Sunday Igboho, the Yoruba self-determination activist who is currently in Benin Republic exile, has not been forgotten by Southwest communities. He was charged with treasonable felony. He fled. He has not been returned. The Oni of Ife is reportedly planning to honor him. The same legal architecture that produced Kanu's life sentence exists for Igboho. The Southwest's stake in getting the legal principles right in the Kanu case is the same as its stake in ensuring that its own political dissenters are treated under consistent, principled law, not selective prosecution. 3 most likely next moves. Move 1. Kanu appeal. Certain, slow. The formal appellate process against Kanu's November 2025 conviction will proceed, likely to the Court of Appeal and potentially to the Supreme Court. The retroactivity argument, the rendition argument, and procedural grounds from the 10-year trial are all available grounds of appeal. The timeline is Nigerian appellate time, which means months to years. Watch for whether the government signals any political resolution separate from the legal process.
Move 2. Congressional follow-up. Possible. Whether the U.S. Congressional Committee that received Arnold's testimony takes any further formal action, requesting State Department briefings, commissioning a report, or inviting Nigerian government representatives to respond, is the key U.S. side signal to watch. Congressional inaction would suggest Arnold's testimony was received as advocacy and filed without formal consequence. Congressional follow-up would signal that at least some members found the testimony credible enough to pursue. Move 3. Southeast political negotiation. Ongoing. Subsurface. The most consequential next move is the least visible. The ongoing back-channel conversations between Southeast political figures and the Tinubu administration about a political framework for the Kanu question. Orji Kalu has said he is working with the federal government on this. Oti has offered to work with well-meaning Nigerians. The question is whether Tinubu's 2027 calculus produces movement before the election cycle locks in, or whether the Kanu question becomes a permanent mobilization grievance that costs APC the Southeast for another electoral cycle. The most significant long-term consequence of Arnold's congressional testimony is not what it does to Tinubu's international reputation in the short term. It is the precedent it sets for how Nigerian domestic political cases are managed in the international arena.
Nigeria's government has historically been resistant to international scrutiny of its judicial processes, citing sovereignty. But sovereignty arguments are harder to sustain when the accused is a British citizen, when the alleged conduct occurred in the UK, when international human rights bodies have issued opinions, and when a US congressional record exists with unanswered testimony. The Kanu case has already crossed from being a Nigerian domestic legal matter into being an international governance question. How Tinubu resolves it, or fails to resolve it, will shape Nigeria's diplomatic standing going into 2027 in ways that cannot be fully managed by domestic political communication.
We opened with a contradiction. The Nigerian government invited Mike Arnold to Abuja, and 6 months later he was at Congress calling for the arrest of Nigerian officials. That contradiction is not resolved by dismissing Arnold as a foreign meddler. It is only resolved by engaging with the specific legal and political arguments he made, arguments that Nigerian lawyers, Southeast politicians, and traditional rulers have also made in different forums without Arnold. The question this video posed, what did Arnold expose about the Kanu case, has a specific answer. He exposed that the Nigerian government has not publicly answered the retroactivity legal argument. He exposed that a British citizen was convicted for speech acts committed in Britain without any UK diplomatic response. And he exposed that the political cost of the Kanu case in the Southeast, in international forums, and in the 2027 electoral calculation continues to accumulate with no resolution in sight. Those are not secrets, they are documented facts. But Arnold's testimony before Congress made them part of an international public record that Nigeria now has to manage. Whether the Tinubu government has the political will to resolve the Kanu question before 2027, and whether that resolution would actually deliver the Southeast political dividend it is supposed to, is the real story underneath this one.
And so, yeah,
Drop your take in the comments. Do you think Tinubu will pursue a political solution to the Kanu case before 2027? And does the Southwest have a stake in how that question resolves? I want to hear your analysis.
So
if this analysis gave you clarity, share it with one person who needs to understand what's really happening. Like, subscribe, and I'll see you in the next one.